Our next witness is Mr. David Reuter, who is the Chairman of the Securities Exchange Commission. We welcome you back once again, and we appreciate your patience in waiting for the conclusion of the testimony of our first witness. We felt it would be helpful for the committee to be able to get the perspective from both of your very important positions on an issue which does have such significance and is commanding so much current attention. And the fact that we can have both of you testify here during one day is of great benefit to the subcommittee's deliberations. So we welcome you, and whenever you feel comfortable, please begin your testimony.
Thank you, Chairman Markey and members of the subcommittee. I appreciate this opportunity to present my views concerning the structure and regulation of the financial services industry. I ask that my written statement previously submitted to the subcommittee be included in the hearing record.
Without objection, it will be included.
As the federal agency responsible for the protection of investors and the maintenance of fair and orderly securities markets, the Securities and Exchange Commission has a fundamental interest in the proper regulation of the securities activities of all participants in our nation's capital markets, including banks and other depository institutions. In recent years, as you know, new forms of competition for lending and deposits have prompted banks to seek new lines of business. Perhaps not unreasonably, they have looked in part to securities activities such as underwriting of commercial paper, securitized debt, and mutual funds as likely areas of new activity. New interpretations of the Glass-Steagall Act, the Bank Holding Company Act, and other laws by banking regulators and courts have given banks some entry into these markets, but have not addressed regulation problems which we deem important. In addition, because Glass-Steagall applies only to activities within the United States, some United States banks are engaged in a broad range of investment banking activities overseas. Pointing to the increased competitive pressures on banks and to banks' extensive overseas activities, some have advocated that the Glass-Steagall Act should be repealed and that banks should be allowed to engage in full-service investment banking in this country. They argue that permitting banks to engage in all securities activities will allow banks to diversify their business, increase their capital, and enhance competition in the financial services industry. Some have also argued that repeal is necessary to make United States banks competitive with foreign banks, many of which are organized in countries that do not separate commercial and investment banking. Whether or not Congress grants banks additional securities powers, legislation is needed in order to apply the principle of functional regulation to the financial services industry. Under such a regulatory policy, banks engaged in the securities activities in the area of the Commission's regulatory responsibilities would become subject to the regulations equally applicable to all other entities engaged in those activities. Functional regulation would ensure that investors in securities are protected by the securities laws, regardless of the entity used in their securities transactions. It would promote fair competition among financial entities on the basis of economic merit rather than regulatory classification. In addition, it would ensure that regulations governing securities activities are interpreted and enforced uniformly by a single agency. To implement functional regulation, I recommend that Congress enact the proposed Bank Broker-Dealer Act of 1987, which Chairman Markey has introduced. That act would amend the Securities Exchange Act's definitions of broker and dealer to include banks that conduct certain securities activities. Enactment of the proposed Bank Broker-Dealer Act would have a number of benefits. Under this legislation, the Commission's ability to maintain fair and orderly securities markets and to protect investors under the federal securities laws would not depend upon the type of entity providing securities services. The bill would ensure that all entities engaged in securities business with the public would be subject to a uniform regulatory scheme. The bill would also facilitate fair competition among entities providing substantially the same services. I also recommend enactment of the Bush Task Force Group recommendation that securities registration and reporting requirements be consolidated with the Commission for all publicly owned banks and thrifts. If adopted, this proposal would lead to more uniform accounting standards and disclosure requirements, enable investors to compare more easily investment opportunities, and ensure that investors receive the same disclosure protections with respect to securities issued by publicly owned banks and thrifts as they now receive for other publicly owned companies. Finally, as Congress considers proposal to expand the involvement of banks in the securities markets, it should exercise care to ensure that banks' entry into these markets is accompanied by adequate protections for investors against the conflicts of interest posed by bank involvement. Mr. Chairman, the task which you and this subcommittee have undertaken is, I believe, an important and challenging one. I look forward to working with the subcommittee in its efforts. I would be pleased to answer any questions the members of the subcommittee may have.
Thank you very much, Mr. Chairman. The Chair recognizes itself for an opening round of questions. Mr. Chairman, you identify 4 main reasons for the enactment of the Glass-Steagall Act. First, the promotion of the safety and soundness of the banking system. Second, the prevention of the channeling of deposits into speculative activities. Third, the prevention of undue concentration. And fourth, the minimization of a raft of abuses related to affiliates. Which of these reasons still concern us and should still concern us, of those that you have outlined for this for the committee in terms of the original enactment justification?
Well, I believe that the problems of protecting bank depositors and bank trust beneficiaries are problems which must be addressed from a banking regulator point of view, and that those problems still will remain, and that in enacting any legislation repealing or modifying the Glass-Steagall Act, this committee must make sure that conflicts of interests and problems do not arise which will injure those groups. These problems, however, Mr. Chairman, are really, as I say, bank regulators' problems, and they reflect concern, I think, during the 1930s. The Glass-Steagall Act, in this respect, reflects concern during the 1930s over protection of banks. The problems which I think are most important and which are with us today are those problems which will arise in the securities industry if banks are allowed to enter into these activities. And it's my firm view, and I believe that of the Commission, that the Glass-Steagall Act should not be repealed outright, but that in any manner it is changed, that close attention must be given to the securities law aspects of bank activities.
Okay. If it should not be repealed outright, what areas should we appropriately look at that would, in fact, deserve modification?
Well, I think in the mutual fund area, you would want to amend the Investment Company Act to provide for protections with regard to possible conflicts of interest. In the underwriting of municipal bonds, whether they be general obligation or municipal revenue bonds, some care might be taken with regard to disclosures in those areas. I think that in the commercial paper area, some study should be given as to again the disclosures of risks. In mortgage-backed securities, which is another area, we have risk problems which ought to be revealed. And in the corporate securities underwriting area, as with mortgage-backed securities areas, one needs to have application of the securities laws to the banking activities, and in order to prevent conflicts. And primarily in all of these areas, fundamentally, we think that the banks ought to enter into their activities through use of affiliates. It's partially for that reason that we have been very anxious to have the broker-dealer activities especially be included in this legislation, or
okay,
in separate legislation.
Okay. In terms of the outline of your concerns: safety and soundness, concentration, depositors, protection, and abuses by affiliates, those 4 problems. You can, I believe, give us some real perspective as a regulator yourself on the ability to protect and ensure for the safety of deposits, even if you're not charged with the supervision of banks. If we did allow for a substantial tearing down of the Glass-Steagall wall, if we did, and even if we don't, the other incursions which are now taking place through regulatory and court decisions and just market forces. Is there a regulatory solution that is possible to ensure the safety of deposits? Can you give us your own considered opinion?
Well, as a regulator, I'm hard-pressed to say there is no regulatory solution. I think there is a way in which the banking system could address basically conflict of interest problems which might arise. The primary problems have to do with use of bank in these areas, might have to do with use of bank assets to protect securities affiliates, might have to do with placing issues underwritten by securities affiliates in bank trust accounts, might have use of selling activities of banks with regard to their customers, and might in various ways jeopardize the banking, the health of the banks. But I think all of these are subject to regulation by appropriate activity by those that regulate the banks.
Okay. In support of functional regulation right now, you state that the securities laws are not very definitive with respect to the securities activity being engaged in by banks. Do you have any sense of the degree to which there may be abuses being inflicted on the investing public as a result of such activities?
It's hard to say whether there are abuses regarding the investing public. As you know, the Commission suffered a defeat at the hands of the Second Circuit with regard to the question of whether we were able to require banks acting essentially as broker-dealers to register with us. In the absence of our ability to regulate those broker-dealers, we're not certain what kinds of activities they're in. We do know that we had approximately 170 bank affiliates registered with us before the loss in that case.
Okay. Well, that's why we're going to be working with you on that broker-dealer legislation. But can you help us just in terms of an understanding of the types of abuses that you're talking about, alluding to? Can you be more specific in terms?
That's an easier question than the question of whether these abuses actually exist. So
you're saying that it's just a theoretical question at this point? We don't know if we're talking about a real problem?
Well, if we're not regulating something, it's hard for us to know for sure whether the persons we regulate are engaged in activities we would think we're bad.
It's very hard to pass legislation to deal with a problem that doesn't exist. I mean, you can imagine how hard it will be for me on the floor to be arguing the need for the bill which I've filed for you if I can't quite identify the problem that we're trying to solve, except in a theoretical sense.
I understand that. You're asking me to give you facts as to problems which exist in this field.
I guess what I would like from you is the the documentation, the facts that led your staff to spend so much time in drafting legislation? I assume that they weren't working in a theoretical vacuum. There must have been some real-world problems that they were trying to deal with.
I'm not essentially sure that the staff believed that its effort to achieve this regulation had to be backed by a whole series of announced frauds by the banking world. I think that what we are aware of is that the regulation of the broker-dealer community does have an extensive series of frauds. We could document you with endless examples of overreaching in the broker-dealer field, and it's for that reason that we have direct regulation of broker-dealers. We have the self-regulatory organizations regulating broker-dealers, including the exchanges and the NASD. And it's our thought that banks in these areas will be no worse or no better than broker-dealers. These are not. I may say that this entry of banks into the system is relatively new, and so we don't have time to develop the case history, which I believe will undoubtedly arise should these activities take place over a long period of time.
So right now we don't know the magnitude of the problem or the numbers that that might be involved at this point.
That's correct.
Okay. Could you just outline for us the the problems you see in terms of tracking tracking financial transactions as we get into this whole concept of bank holding companies and the need for some functional regulation of activities, and what types of problems you would see developing if you were not allowed to, in fact, use the expertise of the SEC in ensuring that there is full compliance with the securities laws.
Surely. If we're dealing, for instance, with the underwriting of mutual funds by banks, there is in the Investment Company Act of 1940 an extensive system of regulation to prevent conflicts of interest, because those people who underwrite and indeed control these mutual funds have varying degrees of association with them. Banks may act as commercial lenders. They may fund the underwriters. They may be sponsors of the mutual funds. They may be transfer agents. They may have they may be servicing agent for shareholders. And the Investment Company Act deals with those problems. We would want to look particularly at the custodian activities of mutual funds, bank mutual funds. We'd want to look at their activities and require separate affiliates. And this is true in all the areas. It's the separate affiliate, I think, that's going to give us the great protection.
All right. What is there any legitimacy that you can give to any point which is made with regard to the lack of necessity of the SEC moving into these various affiliates or other entities that might seek to shield them from full oversight by the SEC and their activities? What weight do you give to their arguments?
I find it very difficult to.
Is there any of their arguments that has any is there anything that you feel compelled to try to address as a potentially convincing argument that would wall out the SEC from regulation in these areas?
I don't find them convincing, Chairman Markey. The arguments usually get into whether or not it's intended, whether Congress intended that this regulation be permitted by the Securities and Exchange Commission. So we're dealing not so much with policy questions, but with the question of whether there is congressional intent. It's my view, and I think, and I know it's that view of all the other commissioners, that since our acts are the important manner of protecting the securities markets, they ought to apply equally to all securities activities. And we can go back and talk about the frauds that existed in the 1930s, which caused the acts to be created, and then ask whether we want to slice out a small part of the community, that is banks, and say, well, these people, if we let them do it, won't engage in these activities. And I think that problem is pretty self-evident, that we need to regulate all people and protect the investors from their activities.
Could you, and I'll conclude on this note. Could you comment upon the capacity of the Fed or the comptroller or any other agency to do a job that you are now doing and could extend into these affiliates or other entities?
Well, I suppose that the Fed could gear up a whole similar Securities and Exchange Commission to do all of the things that we're doing. It wouldn't make a great deal of sense to me. Seems to me it's quite easy to ask the banks to put their securities industry into affiliates and let us regulate them the same way we do all other people.
Okay. Would you need additional personnel?
Yes.
How much? How many more people?
It's hard to tell depending upon what activities we are asked to regulate. Certainly, if the municipal securities industry, if we were asked to regulate in the municipal area, we would need substantial additional resources.
Okay. And you would need would you need new types of people coming into your agency? Or would it just be more of the
more of the same, I think.
More of the same.
Yes.
Okay. Would it be? I mean, would it be a substantial increase in the personnel of the SEC that you would have to request to Congress if you were moving into these areas?
Well, I've already in some of my public statements at least indicated I think there's a need for an increase in commission personnel, but it depends whether you think 10 or 20% is substantial. I think in that range we could deal with the bank with our current needs and with the bank and banking regulatory problems.
What I would think 10 or 20% increase would probably be viewed differently by OMB. You know, it all depends on the eye of the beholder. My time has expired. The chair recognizes the gentleman from Tennessee, Mr. Cooper.
Thank you, Mr. Chairman. Chairman Reuter, I don't want to be too hard on you, and let me assure you that I have the highest regard for you personally, but I was somewhat...
Watch out, Mr. Chairman.
I was somewhat disappointed by your testimony. The subtitle of it, or title of it, says, Concerning the Structure and Regulation of the Financial Services Industry. And then what I read, or let me be accurate, what I skimmed later on, indicates to me that you're really taking kind of a neutral, passive view of this whole battle that's going on before us. I asked Chairman Greenspan whether he was wanting to turn back the clock or whether he hadn't had a chance to get his feet on the ground yet. In my opinion, based on this testimony from the SEC, y'all are hiding behind a tree in this fight. To me, the American Institute of Certified Public Accountants could have come before us and said, I don't care what you do, just do it according to generally accepted accounting principles. That's basically what you're telling us. I don't care what you do, as long as it's in a separate affiliate and if there's functional regulation. And to me, I don't know too many people who would quarrel with that. Most everybody I talk to is for functional regulation and for separate affiliates. But that doesn't...
Well, I'm glad to hear that.
Well, it doesn't reach the fundamental policy questions underneath, though. It's my understanding that your predecessor, Mr. Shadd, said that it was fine for banks to get involved in revenue bonds and mutual funds. I read the mutual fund section of your paper, and it's kind of like, well, put it in an affiliate, and there are going to be some conflict of interest problems, and we'll go from there. It's so passive, and we need guidance on what powers or lack of powers banks should have. And to me, I was, as I say, somewhat surprised when I read your testimony.
Mr. Cooper, I commend you for your reading of my testimony. You read it correctly. It was intended to be passive. In that sense, it was intended to be. It was intended to state, I hoped very strongly, and not in any namby-pamby way, the Commission's view that if bank activities take place in the securities industry, they must, for investor protection purposes, take place in affiliates. Now, with regard to the question of whether those activities should be taken by banks, the reason that my testimony did not include the two statements which Chairman Shadd made were precisely because I am reviewing these materials for the first time. I am, in my 2 months in office, I found a great many matters which I've had to address: insider trading, tender offers, program trading, and lots of other areas. And Glass-Steagall is an area which is farthest away from my prior experience. So what I want to do is to look at the possible activities of banks and ask myself whether Chairman Shadd's list was extensive enough. I want to ask the question this way. I want to ask, what kinds of legislation would the Commission suggest if the Glass-Steagall Act should be repealed? And when I can make that analysis and ask in the kind of detail that Chairman, in a kind of more detailed way, the question that Chairman Markey was asking me, then I think I will be able to come back personally and say to you, well, I think you can go down the list of all these things, but here's a point at which we think we should stop. Or I may come back and say, in my opinion, we can regulate it all satisfactorily. Then I would have to come back to you and say, this is Chairman Reuter's testimony and doesn't carry the Commission with it, or does. And that's still another question for me.
How long do you think that this review will take?
Till December 1st.
Oh, we welcome you back at that time when you've made up your mind on these questions. So you in no way mean to imply today that you were looking at turning back the clock. You just want time to make up your mind, and I believe the key phrase that you used was you were checking to see whether Chairman Shadd's list was extensive enough. Was that the phrase that you used? Implying that it might be a longer list instead of a shorter list.
Or could be much shorter.
Okay,
I mean,
so
I
you're
just
giving
didn't
yourself leeway both ways.
It's only, yes, I was.
It'd be harder to have a list shorter than a list of two.
Oh, well, one or none.
Even granting your indecision at this point on the big questions, your recommendation of the affiliate as the panacea worries me, because while I think affiliates can do a lot of good, many people have questioned whether the affiliate barrier is sufficient insulation. And I would hope that you would re-examine that premise at the same time, because
I think it is a very serious question. It's serious from both the parent's point of view and the affiliate's point of view. The questions go two ways. One is, will the parent drain the affiliate of necessary assets so that the affiliate can't run? That's injurious to the securities business. The other one is, will the parent drop assets into the affiliate, which will make the banking function difficult? So I think we need to deal with that question in a two-sided way.
I agree with you, and that is one of the reasons I'm so amazed at your testimony. You're so definite in being all for affiliates when you have substantial policy questions about how effective that insulation device could be.
Well,
but yet you venture no opinion on the larger policy questions about what businesses banks should be in.
It says if the Glass-Steagall Act is repealed. Well, it doesn't. It goes further than that. It says all securities activities should be in affiliates. The same problems will take place if the banks do them themselves. The same problems may exist. We want to have it in affiliates so that the affiliates can be regulated as though they are securities industry affiliates.
Another part of your testimony that worries me is you point out numerous conflicts of interest that could arise, and I appreciate your doing that. That is very important. I don't mean to minimize them in any way. But lest folks only attend this hearing, they might think, well, these are the only types of conflict of interest that exist, when in my opinion there are substantial current conflicts of interest that we hear from you about in other hearings and other aspects of our jurisdiction. So I wish there were some way to put this in balance, to let folks know what conflicts of interest exist today and are not being dealt with perhaps as well as they could be, versus what conflicts of interest could exist if banks were allowed to pursue some of these activities that they haven't been allowed to pursue in the past. Would you agree that that's a fair, balanced way to look at it?
If I understand you correctly, you're asking whether we can identify conflicts of interest which are particular to banks.
Well,
and perhaps at the same time asking us to look whether there are conflicts of interest in the securities industry which should be addressed, which are not now being addressed. I will tell you that one of our main tasks is to identify these conflicts of interest in the securities industry, and that we are actively looking at these various areas. We sometimes move a little more slowly than one might like, but we are looking.
That's why I say we hear from you in other hearings about the other types of conflict of interest, and just so that members can put it in perspective, the new types of conflict of interest that you're mentioning today should be added to the list that you're already examining that are currently involving securities firms and, to a smaller extent, some banks.
I think that's fair to say.
It's really my two-way street question that I asked Chairman Greenspan. It's not just a one-way street, it's a two-way street. And the extent to which different firms invade others' areas, it creates problems whenever that arises, not just when banks happen to want to get into the securities firm area.
Yes, I think that's true.
See. I have no more questions this time, Mr. Chairman.
His time has expired. The chair recognizes the gentleman from Utah, Mr. Nielsen.
Mr. Ruder, I'm glad that my colleague from Tennessee is willing to let you have December 1st to solve a problem we've been wrestling with for 50 years. And the committee,
He volunteered that.
the committee,
the
committee on which he served for 4 years, as I recall, came up with nothing in this area, even though the problems were just as great in the last 4 years they are now. Now, having said that, let me go back to your affiliates as well. I have a different objection to your affiliates. You say on your testimony, page 12, banks are permitted to underwrite municipal revenue bonds. They should do so only in separate affiliates fully subject to the federal securities laws. Then you go on to say that you have the similar activity involving general obligation is already regulated by the Exchange Act concerning these municipal activities. Why couldn't that same act handle revenue bonds as well as general obligation bonds? Why would it have to be a separate act or a separate arrangement affiliate, since you already have the regulatory power over the general obligation bond?
If I understand your question,
I'm just quoting you.
where are you quoting on page 13?
Page 12, under A, municipal revenue bonds, page 12 of your testimony.
Yes,
If banks are permitted to underwrite municipal revenue bonds, they should do so only in separate affiliates, fully subject to federal security laws. And then you say a very similar activity, bank underwriting of general obligation bonds, is regulated by the provisions of the Exchange Act concerning municipal securities dealers. Couldn't that same act cover revenue bonds as well as general obligation bonds?
I'll have to just ask one of my staff. I'm not. We do regulate that activity, and it's my understanding that it
But
is
why would it
in
have to be a
affiliates.
separate
If I can
affiliate
ask
to do
question.
that, since you already have that regulation?
I would ask Rick Ketchum, my director of market regulation, to answer that question for me, if you may.
This is aside from the fact whether you need an affiliate or not. I'll concede you might want an affiliate, but I'm wondering why you would need separate legislation or separate provisions, since you already do it for general obligation municipal bonds.
Congressman Nielsen, the municipal securities provisions in the 1975 Reform Act provided somewhat of a hybrid system of regulation. First, the banks were not required to split that activity off into affiliates. They were permitted to continue to do it within the bank in a separately identifiable division. Secondly, the SEC was not given the primary examining authority over that. Instead, that primary examining authority was left to the bank regulatory agencies, while the SEC continued to examine the municipal dealers who were not banks, who were securities firms.
But why would you need a separate affiliate if you went to revenue bonds as opposed to general obligation bonds?
I think the point is that looking, and this has generally been a conclusion accepted by all the regulatory agencies, as you look to a number of significant additional bank powers, not just municipal revenue bonds, but also perhaps in the area of mortgage-backed securities and other things proposed by the legislation, that this hybrid approach doesn't make sense. It becomes very difficult to go in and take a look at a banking operation as part of a separately identifiable division. It begins to not make sense as securities activities of banks becomes a more significant part for a separate regulatory agency
you're taking me further than I want to go. Just talking about revenue bonds or backed by municipalities and states.
Just
I
to
don't
give
want to
my,
go beyond that at this point.
I think our conclusion was that the present situation is not preferable. It is preferable to have the SEC examining rather than the bank regulatory agencies examining for banks as well as broker-dealers.
You already have that power.
No, sir. Only on a backup basis. The bank regulatory agencies do the examinations of bank municipal security dealers.
Are you saying the statement on page 12 was wrong? That's already handled by...
I believe what the statement on 12 says is that the SEC has overall review authority, but that the bank regulatory agencies are the primary examiners.
The statement says, is regulated under the provisions of the Exchange Act concerning municipal securities dealers and the rules promulgated by the Municipal Securities Rulemaking Board.
Could that not be extended very administratively to revenue bonds as well?
Yes, sir.
Yes, it could.
That's my point.
It could, sir.
Without making an affiliate.
You asked how it was being done, and my answer would be the same as the testimony is, that by far the preferable way is to have these activities conducted in affiliates so that we could be the primary investigatory and regulating agency.
Yeah, but the way you handle the general obligation bonds, is that satisfactory to you now?
That's the question I brought Mr. Ketchum up, and I think his answer would probably be no.
It is acceptable. I don't think it's preferable, no. I believe it is not the best system to have different agencies examining for the same regulatory requirement. The result is you have different interpretations, different levels of enforcement.
My question, if it's worked since 1975 and you haven't objected to it, why could it not also work for revenue bonds?
It seems to me that the fact that a system is acceptable and can be improved is not, if one is going to go about adopting new legislation, is not a reason to look and see whether there's a preferable way to approach it.
Why have you not proposed legislation since 1975 that's not acceptable?
That's not what I said, Congressman Nielsen. I said that it is acceptable. It works acceptably now. If we were looking to expand banking powers...
You can't have it both ways.
Could I interrupt for a minute, sir?
It's either acceptable or it's not. If it's acceptable, it can be applied to revenue bonds. If it's not acceptable, then let's change it and go back and put revenue bonds and look at that issue.
I am currently involved in an initiative at the Commission in which we plan to look at the regulation of the general obligation bond disclosures, and we are looking at the municipal revenue bond disclosure system. We are looking at the underlying disclosures and the disclosures of call and put provisions. And I think you are correct that we should be looking at them together. I cannot now predict which way we would go, except to say that I think that it makes sense to have the two regulatory systems, a system of municipal revenue bonds and general obligation bonds, be regulated the same. I think that my testimony indicates that our approach would be to use the affiliate system with regard to these activities.
In answer to a question from Congressman Moorhead, Mr. Greenspan said that the domestic banks are at a disadvantage in dealing with foreign banks because foreign banks can do things in this country that domestic banks can only do in foreign countries. Do you feel that we are putting our banks at a competitive disadvantage because of the Glass-Steagall Act or because of the other laws? And if so, are we inviting foreign finance to take over our country financially?
Well, the latter point I can't agree with, that we're asking foreign banks to compete to take over our country in that sense. There is a list of, I understand, 15 banks or so which have exemption from the regulation of securities activities of their affiliates in the United States. Some of them do, those 15 banks do have affiliates, and they are not regulated the way our banks would be regulated. They're engaged in full-line securities activities. And in that sense, there is a competitive advantage to foreign banks in the United States. But as I understand it, not other than those 15 banks.
Mr. Greenspan said the most prominent regulatory structure for expanding bank securities activities is to use the bank holding company model, allow these new activities to occur in separate affiliates. You apparently like separate affiliates, but do you agree with that statement?
That the most effective way?
Most effective way, most promising regulatory structure for expanding bank securities activities is to use the bank holding company model and allow these new activities to occur in by separate affiliates.
Yes, I think I would agree with that.
Agree with that. Okay, banks argue that underwriting commercial paper is very safe. Is underwriting other types of securities of top-tier corporations just as safe, in your opinion?
No. Underwriting commercial paper is thought to be safer because commercial paper usually has a very short-term expiration, probably 3 months, and it's very unlikely that
So it's more liquid.
It's more liquid, and it's very much more unlikely that the safety factors of a particular issue would diminish in a 3-month period, whereas when underwriting securities of longer duration, one has to be more concerned about the safety of those instruments.
Let me ask the general question I started off with. Banks have been permitted to underwrite general obligation bonds, municipal bonds. Should they or should they not be allowed to consider revenue bonds, with or without your affiliate system?
Here we'll speak personally. I heard Mr. Greenspan's testimony. I tend to have some concern about the disclosure aspects of municipal revenue bond offerings, and I would want very much to be assured that there was a sound regulatory system in place offering proper disclosures before I would agree that banks should automatically be given that power.
May I ask the 2 questions I asked, added to your list, for Mr. Reuter as well, whether banks should be permitted to sell mutual funds and whether banks should be permitted to sell insurance? And also one other question on consumer confusion, because I think there's a good deal of confusion about what's safe and what isn't in what the banks already do. I want to know how that could be extended. The Chairman will indulge me. I'd like to submit those questions in writing.
Okay. We will.
If you submit them in writing, sir, we will answer them.
Okay, great. Gentleman's time has expired. Just let me ask a fundamental question here, which is, if there was a bank holding company constructed that had a banking capacity and a securities capacity, how would you regulate that in your ideal regulatory structure in terms of the interrelationships between the various federal agencies?
We would regulate the affiliate of a bank holding company the same way that we now currently regulate an affiliate of a industrial company. General Electric, for instance, owns a securities broker-dealer.
Who would have primary regulatory oversight responsibility for the bank holding company itself, for the mother company? Would that be the Fed, or that would...
It might very well be that you would, that as long as one were satisfied that the bank was protected, that the regulation... let me put it this way: there's another group to be protected in banking, which is not protected in the securities industry. That is the depositor. It might well be that the overall regulation of the banking industry would require Fed regulation of the bank holding company. But I really have not a firm view on that, Chairman Murphy.
What do you say to those that would argue that Security Exchange Commission just doesn't have the detailed working knowledge of how the banking industry operates, and that all of these banks already have regulators who are sensitive to the issues that we are discussing, and that they are in place right now, in residence, and understand this industry, and giving them this additional responsibility is really consistent with a unified oversight of this industry? What would you say to those people?
Well, I would say that, if I understand the question correctly, that that's an industry regulatory approach rather than a functional regulatory approach, that the Commission has adopted the fundamental thought of functional regulation, so that we ought to regulate the securities activities and let the banking authorities regulate the banking activities, and then decide who regulates the holding company.
Okay. So I guess what I'm asking, if I can be, again, I don't want to put too fine a point on this, but I guess I can't avoid it, is the banking people are not qualified to do the types of work that you at the SEC and your personnel have been trained to do, and that they would not be able to have the sophisticated appreciation for the types of abuses of public trust that might be engaged in. Is that what you're saying?
Well, I don't think they have the experience and background and depth that we have, and I think it would be remarkably inefficient for them to create that now, and therefore I suppose my answer has to be yes to your question.
Okay. And I'd like to move over to the question of the oligopolization of the securities industry.
Mm-hmm.
In your mind, is there right now a fully competitive securities industry? And are there high or low barriers to entrance by new competitors into the marketplace?
I have not been of the view that there is an undue concentration in the securities industry area. I think Mr. Greenspan was correct when he said there's a relative ease of entry if sufficient capital exists. The one area that I have some concern with, strangely enough, is not the activity inside the U.S. markets, but outside of the U.S. markets. In the foreign markets, we have banks able to operate in the securities area, banks, not only foreign banks, but domestic banks, so that in some sense the regulatory system is so much different overseas that it may have create some competitive disadvantage to our own securities industry.
Is there a concern which we ought to have with regard to the doctrine of unintended consequences, where a Citicorp or others could begin to move in and have an intention of gobbling up the securities firms, and as a result there may be less rather than more competition? Is that possible?
Well, everything's possible. I don't regard it as very likely. And
why is that?
Why?
Why is it not very likely?
That Citicorp would gobble up the securities firms to the point that they would have an undesirable concentration.
Mm-hmm. Not Citicorp
I mean
but
a bank
in
like
conjunction
Citicorp.
with a small
Yes.
number of other.
I don't want to take on Citicorp today.
No, I understand that. I don't mean to point out. And I really don't mean to point to Citicorp. I use them just as an example. I mean, if we see individuals who are able to move in, Revlon, for example, at Solomon Brothers, why is it not possible for us to anticipate that these worldwide banking entities wouldn't see the benefit of having their own already well-developed, sophisticated investment banking, merger and acquisition, arbitrage units that they can buy?
I will give you the same answer that I gave to you, I think I gave to you or should have given to you in the takeover situation. I simply don't know which economic consequences are going to be the best and which are not. I would tell you that in terms of unintended consequences, one unintended consequence of removing the Glass-Steagall Act might be for the securities industry to go out and gobble up banks, so that you would now have the banks being sold to the securities industry. And one can't tell what's going to happen.
Right. Is it important then for this subcommittee and for the Senate side to, as a result, move very cautiously in this area? Because we should understand as best we can the implications of our actions, even though it is unknowable in its final form what would be the consequences of taking off any of these restrictions, but that the deliberative process ought to be one that involves a very thoughtful and if necessary, prolonged deliberative process to ensure that we have fully comprehended as best possible the ramifications of our actions? I mean,
Yes.
should we be how much should we be bound by the March 1st deadline?
Well, I'm just going to say, my answer is yes and no. Yes, you should be very cautious and careful, and try to guess the intended and unintended consequences of any action you take. But I guess personally I would join somewhat with Mr. Greenspan to the effect that the market forces are moving, and an impediment against market forces is one which is very difficult to justify. And I again say that I think the worldwide market forces are moving, and particularly in the securities industry, at a level and a rate which I can't come anywhere near to predicting. If you talk about unintended consequences, who knows what problems would arise from keeping the March 1st deadline.
Okay, well, deal with that for a second. The question of whether it is better to extend the March 1st deadline if Congress has not acted at that point, whether it would be worse in its overall consequences if we extended that moratorium and did not allow it to lapse.
Well, I have in my notes that I should insist that the legislation that you introduced be passed by March 1st in order to in order for us to have a handle on the broker-dealer community. But I say that somewhat in jest, because I know that you cannot, the Congress cannot deal with this well, probably not want to deal with it in isolation. I think that that the world got along pretty well without the March 1st deadline before, and it doesn't sound to me as though one ought to be terribly concerned that there is or is not legislation in effect by March 1st. It's certainly important.
I guess that, if I might interject, is that there was considerable sentiment in Congress that the world wasn't getting along very well without that moratorium, and that there was some need for some deliberation and perhaps some action. So it is a debatable question, and I guess a lot depends upon whether you are a regulator, a court, or the Congress in terms of how well you thought the world was being dealt with.
I think you have greater responsibilities for the world and the economy than the Securities and Exchange Commission does. I think we have an important function, and that is to make sure that our capital markets are viable and that our investors are protected. And that's the viewpoint that we come from primarily.
Again, just to conclude, you would prefer, though, that the moratorium lapse even in the event that Congress has not acted?
Personally, I think I would subscribe to that, but I don't do so with any great depth of knowledge, sir.
Okay, and can I ask what new developments you might reasonably anticipate could occur if that moratorium did lapse? What new pent-up ventures, concepts, ideas might we begin to encounter at that moment in view of the fact that there has been this dam which has been built for a year-long period?
I would expect the pressure to come primarily at the Fed level from the banks trying to get the Fed to allow them to get into some activities that they may not, they may or may not be able to go into. But I can't give you a chapter and verse on that subject.
Okay. My time has expired. Once again, do you have any other questions?
Yes, I do. I'm glad you answered the question the second time. You're willing to let the March 1st deadline come and the moratorium drop off?
Yes, sir.
And what implications does that have for SEC if it does expire?
It has.
Assuming Mr. Markey's fine legislation that you prepared does not pass by that time, do you see any real problems with the SEC?
Well, one can't tell. We think that we ought to be able to regulate the broker-dealer activities of banks and do it directly. We have other weapons, if you will. We have anti-fraud weapons. We have some enforcement tools that are not necessarily related to those areas, and we will use them if we find out that that activities are being taken which are wrongful.
Another question asked Chairman Greenspan. Does the Glass-Steagall wall make any sense in view of the affiliations Goldman Sachs and Sumitomo Bank? Sumitomo Bank and Goldman Sachs have an affiliation which allows the banking and the securities to work together. Does the Glass-Steagall wall make any...
Overseas, yes.
Does the Glass-Steagall wall make any sense in that case?
Well, I indicated earlier in my testimony, I think there is a substantial concern about whether or not the competitive positions of American entities will be overly, will be negative when there is overseas activities in which banks and securities activities are combined. I would make one caveat. We have the best capital market system in the world, and it is highly regulated. And my view would be to attempt to persuade the overseas regulators to come up to our level of regulation rather than having us have to reduce our regulatory activities.
But that's not
here.
what's happening. Other countries are deregulating the financial institutions, such as the big bank in London. What impact is that going to have on foreign deregulatory effects of the United States?
We are looking into the question of what compromises we should make, but it's very early in the game, and there are certain activities, I think, which they may well come to believe are better regulated. I'll take insider trading as an example.
You were suggesting, were you not, that we'd like to convince the foreign people to regulate more like we do?
Mm-hmm.
And the opposite is happening. I'm wondering what effect that's going to have on your stand here.
I've only been in office for 2 months, and I can tell you that I will make every effort to induce regulators abroad to understand the benefits of our system. So I can only tell you that that particular area has been moving with such rapidity and so many dramatic consequences that we, and I think the regulators abroad, are a little reluctant to come storming in with new regulations in order to see what's going on until we know what the areas of concern may be. I can point to several now, but we're not yet in a position to regulate them.
I thank you, Mr. Reeder, and thank the Chairman for his indulgence.
I thank the gentleman from Utah. Gentleman's time has expired, and so has the time for this hearing. I would ask in conclusion that you respond in similar fashion to the subcommittee as Chairman Greenspan has agreed to, which is that rather, and I will not repeat at this time the core questions which I asked of Chairman Greenspan, but that you at the SEC as chairman and the staff prepare for our subcommittee a response to those questions and other questions which our subcommittee can work out with your staff that the SEC has particular expertise in dealing with. My own feeling is that your response to these questions will be in no way repetitive or cumulative in terms of the responses which will be given to us by the Fed, but that by your own testimony here today, it is clear that your agency has real expertise in areas that will be absolutely critical if, in fact, some of the decisions which are now pending before the Congress are made in a way which allows for banks to enter into areas and activities which they have heretofore been prohibited. So we need your guidance. We need your counsel. We need to know what types of protections, what types of changes, modifications might have to be made in order to ensure that the public is protected, that competition is advanced. And I would ask that you abide by that December 1st deadline as well. I know that it is, in fact, a relatively short period of time, but on the other hand, the consequences, if indeed Congress does take action, will be severe if we enter into this area without the proper information. By way of additional information, we are going to make the same request of the chairman of the FDIC, who is appearing before our committee on October 14th. We'll make the same request of the Comptroller of the Currency, of the Justice Department, Antitrust Division, and of the Department of Treasury, so that we can also receive their comments on what types of governmental changes would be necessary in order to ensure the full protection of the public. Do you think it would be possible for you to comply with that request in terms of your agency's response to the questions which I have already posed to Chairman Greenspan?
Well, we will certainly do our best, and I would like to say that we will probably bring you a report that would be in two parts. One would address the securities law implication of repeal of the Glass-Steagall Act, indicating what changes in the securities laws we think would be necessary in order to deal with problems that might arise. and secondly, a more generalized statement regarding policies. We may not have the expertise and staff to do the broader kind of studies that you've asked of Chairman Greenspan, but we'll do our best.
Okay, I would just add and ask, in view of the extensive public comment which I read about the views that the economists at the SEC and their views on mergers and takeovers and their effect upon the economy or insider trading, as opposed to the views that your enforcement division might have on some of those very same issues, that there is, I understand, an ongoing internal debate. But I don't think that it's for lack of expertise or background that your agency would not be able to produce any kind of substantive analysis of these issues. What I would ask you to do is to resolve any differences which might exist in your agency, because I'm quite sure that the expertise does exist, so that we can have your recommendations. We have to have them if it is going to be, in fact, a thoughtful and rational process that the Congress will engage in. We can't act without them.
I'm much more confident about giving you Commission-endorsed proposals for change in the legislative system than I am in a Commission-endorsed view of the Office of Chief Economist. But we will do our best to achieve whatever
I understand that. But on the other hand, it is very difficult for us, and I do understand that difficulty, but it is very difficult for us to act decisively in areas of complex public policy if all we have to base our decisions upon are watered-down recommendations or analysis in key areas from the agencies that will be primarily responsible for dealing with those areas once the legislation is passed. And I, for one, would resist any movement by this committee in the absence of that kind of documented, eye-watering detail from the agencies of jurisdiction as a precondition to any legislation being considered, just so you can understand the necessary position which our committee is in.
I understand your point.
Okay, thank you. So we thank you once again. You've been more than gracious, and we hope to see you again in very early December for a follow-up hearing after the recommendations and analysis from the Commission has come to the subcommittee.
Thank you.
Thank you very much, Mr. Chairman.